Divelbiss. I am a future first criminal law. I am making this video for you on 8 of the frequently asked questions that I get. I have a previous video where I go into some of the background of myself, my firm, things that defense attorneys do in our investigations and representing clients. And this is a little compilation that's definitely not all inclusive of 8 of the things that like I said, I frequently get asked. There's some of the bigger questions that you should know. And then just know as well that I have more videos that go more in depth on each of these different things that are happening. So I want to briefly break into them and give you a big overview of it here. So the first one is, I'm innocent. Can you get my case dismissed? Quite simply, the answer is probably not. Not that simple. And I know I go into this more, and if any defense attorney goes, "Oh, you're innocent," yeah, your case is definitely going to get dismissed. I hate to be the one who tells you this, the bearer of bad news, but that attorney's probably just placating with you, wanting you to believe that they believe you just right off the bat. If it was that simple, you would never hear one of those news stories of, wow, this man or woman after 20-30 years was now found innocent and released from prison. So that's not the way it works out here in Maricopa County, in Arizona, in any of our city courts or any of our felony courts for misdemeanors, felonies, anything like that. And I just want to give you that just right out the gate and let you know that it's not that simple. Furthermore, though, I'll get into this saying that there are pretrial motions that we file. These are formal requests, motions. That's why we went to law school, to learn how to write these motions, how to write arguments that are successful to a judge. These are ways that we can get the case dismissed, before we get to a trial. But something you should be aware of is there are very few motions like this that, one, are usually are even successful, or number two, that are even appropriate, because ultimately the claim of innocence isn't a valid reason to get the case dismissed. And I know I'm saying that just as a big overview, because of course if you are innocent, then there will be more things that say or prove why you're innocent. And so I don't want you to take that, just off the face value of what it is. Because there are many different things where, if there's true innocence in a case, that it will be discovered, that motions will actually be able to help. But there's no motion to dismiss because I'm innocent. It's not that simple. It's not that easy. And anybody who tells you that it is, like I said, is probably just pulling your leg and wanting you to hire them in order to help out. Once again, to kind of go a little further there, because if that doesn't work, as far as filing that motion, we go through along the process of the criminal case in the criminal justice system. You end up pleading not guilty right out of the gate to make sure the judge says, great, this case is going to go on further. Then we go through, we gather evidence, and we find ways to prove your innocence. And then ultimately it goes to the trier of fact. That's your judge or your jury. That way they can review all the evidence and determine whether you are guilty or not guilty. This is important. This is, like I said, what I go into deeper into other videos. Arizona has, some unique rules. I think they're very similar to many of the other states. But at the very end of the day, at the end of a trial, there's a sheet, and the jury gets to fill out the sheet, and next to it a box that you got to check or circle. And I'll tell you what, none of those answers are innocent. Innocent written down there. What it is, it's going to say guilty or not guilty. And that's just the bottom line of it. And what this really means is the criminal justice system is not here to prove your innocence. Once again, let me say, the criminal justice system is not here to prove your innocence. It is here to determine whether you are guilty or not guilty. I know it might, without deeper understanding, going into some of my other videos and getting the understanding here, but just briefly, there is a big difference between innocent and being not guilty. An experienced defense attorney knows that, recognizes it, and it's why we go for the not guilty verdict at the end of the day. And we don't try and tell the jury you're innocent, that you have never done anything wrong in your life. They get all kinds of different, preconceived notions of what innocent means. means, and it's essentially digging yourself a higher hole if you're truly not innocent. Of course, if you are actually innocent, there are many ways to prove that pre-trial, through discovery, through evidence, through deviations, through motions that us as experienced attorneys at my law firm, we know how to do and use and have done successfully for many years. The next thing that I want to mention here is a question that we get asked frequently as well, is if the alleged victim does not want to press charges, will the charges be dropped? This is your typical situation: domestic violence cases, trespass cases, some criminal damage cases. And the simple answer is not necessarily. In almost every situation, it does not mean the case will go away. Except I don't want to say that sometimes in very rare situations it does happen. But even if the alleged victim does not want to press charges, the prosecutor may choose to go ahead with the case anyways if he or she can prove the case without the victim's testimony. Very important thing right there. They still have to prove the case. They still have the same beyond a reasonable doubt standard that they have to get to. The prosecutor may consider the wishes of the victim and or witnesses, but ultimately the decision belongs with the prosecutor as the representative of the people or the state of Arizona. And it's typically the state of Arizona that brings the charges against you. It's not the victim, it's not the person that you harmed, damaged, or threatened in any way, shape, or form. And that's something that many people don't understand and wish that it was true. And there's a lot that goes into this. It's in more of my other videos of why it's not this way, and maybe for good reason or not good reason it is or isn't. What I will say though is the views and wishes of the victim is very important. If they do not desire prosecution, this is definitely one of the things that very well could lead your case to being dismissed before trial or potentially even at trial. Keep in mind, like I mentioned, the prosecutor still has to prove the case beyond a reasonable doubt, which means if the victim doesn't testify, they have to have the police officer testify. Well, the police officer wasn't there, didn't see anything, their report's inadequate, then that's going to be a pretty steadfast way to get the case dismissed. However, you're going to be towing a line if you're trying to do this yourself, and if you're thinking that you're going to call the prosecutor's bluff when the prosecutor says, no, we're going to trial, I don't care if the victim doesn't want me to go to trial, we're going to do it anyways, and you say, okay, well, I'm going to call your bluff, and you end up in trial, the police officer shows up, you have to have a trial. You can't just tell the judge all of a sudden, oh, hey, judge, they showed up, I want to go hire a lawyer now. A judge will be very upset with you, maybe will allow you to get a short continuance to go and hire a lawyer. Just know you're not really setting a good look for your case and for your decision making. You really need to do all of that stuff beforehand. So, big question that we get, and it happens a lot here in Arizona, especially these days with many of the things that people are experiencing on a personal basis, and what really leads people to commit some crimes or make 5-minute mistakes that they end up regretting, that everybody understands is not the true nature of that person. Either way, number 3, will I have to go to trial? Maybe not. Usually, most likely not. In fact, there's a statistic here in Maricopa County that 97.5% of cases do not go to trial. So that really only leaves about 2.5 of the cases that are charged that end up going to trial. What that means is most of the cases are resolved by plea bargaining, which is an out-of-court settlement negotiation between the prosecutor, you, defense attorney. It's approved by a judge. It doesn't go to a jury, and if you're not offered a plea agreement or you choose not to accept a plea offer, then that is the time that your case will go to trial, whether that is a jury or a judge trial, depending on the charge. Something that's important here, especially with cases that in my 2.5% that make it to trial, not every case gets a plea agreement. Some cases are forced to go to trial depending on typically the more serious nature of it. And of course, there are many cases that are dismissed. Those cases that are dismissed get factored into the 97.5% that don't make it to trial. A lot of cases get charged and dismissed for many different reasons. Typically, a case isn't going to be dismissed just on its own. You typically need a good lawyer, a good private attorney that can come in and show that your case is warranted a dismissal, if in fact it is, or if it's kind of teetering the line and it needs that extra push, the nudge. then that's all the more reason a good defense attorney can come in, such as myself, and help make that happen. Of course, there are many different factors that go into every single case. Every case is different, and that's the big thing that you need to do to assess your case, is to get a good private consultation, which is what we offer. It's free, it's confidential, and you'll get a lot of those questions answered, and hopefully get the desired outcome that you are hoping to achieve. Continuing on, if I'm offered a plea deal, should I take it? That's right here in the middle. The decision to plead guilty to go to trial is unique to each individual, just like your case is unique to every situation and every person that it is involving. Anyways, juries are unpredictable and no one can calculate precisely what your chances of acquittal are. This is important because as part of this, we get asked a lot, well, what are the chances that this happens? And can you give me like a percentage of how, confident you are, or how likely this is to win? And that's the part where, honestly and ethically, we as defense attorneys are not allowed to. We can't give you this false hope, this false sense with some kind of statistical backing that says, yes, 60% of my cases have ended this way. And it's just not the reality. It's not ethical to say that, because the reality is your case is different. Even though you might have the same charges as the next client, you both may very well get a different result. And that's the nature of two separate cases, of two different individuals, two different, mindsets that went into, whatever happened, the background, the situation, the scenario, the evidence, the testimony. All of that comes into play as a factor in whether you get a similar or better or worse outcome as somebody else. And that's why it's very important, as I go through here and mention that some of the things that are factors to consider are always going to be, what do the witnesses say? If you're going to make a decision between taking a plea agreement and going to trial, what are the witnesses going to say in your case? Are they credible witnesses? Are they going to appeal to the jury? Keep in mind, witnesses means police officers. Police officers who have pulled you over, arrested you, found you at your house, found you wherever, they're technically witnesses. And we mean, how are they going to appeal to the jury? Police officers are trained. They're literally trained to speak to juries. There is a method to it. There's ways that you're supposed to make eye contact, body language, things that you're supposed to say, not to say. And it's a big deal. There's a lot of science behind it, and that's what your defense attorney takes into consideration. Of course, there are lay people, your regular average citizens who are witnesses as well. And hopefully, if there are good witnesses or bad witnesses, that becomes a factor that you should consider. Of course, I have a lot more in other videos that goes into this, but I'm going to continue on here and saying what evidence the prosecution has against you. That's going to be something that obviously is very important. If they have a lot of evidence against you, then maybe it's a plea agreement that you want to take at that point. If they have minimal evidence against you, then maybe it's the trial you want to take. If they have a lot of evidence against you, but it's not about something you're charged with, then maybe you do take a trial offer, or you go to trial, or you take the plea agreement. There's a lot of things that kind of play into this, and that's what hiring a defense attorney really leads you to understand, hopefully in a coherent way, if you hire our firm. But if you're just talking to a public defender, some other attorney who isn't well trained or experienced in the way plea negotiation, trials, and evidence works, you may end up being more confused and focusing on something that you really shouldn't be focusing on, which is a common mistake that really confuses you and might not be helpful in the end. And something to even be further considered with that is all the pretrial work that goes into it. If the evidence was or wasn't lawfully obtained, we obviously make decisions. We file the motions I mentioned earlier to suppress evidence, to remove it, in motions in limine to get it omitted from a trial, so nothing about that can come into the trial. Those are things that are very important, that are advanced moves that I talk about in other videos, explaining motions to suppress and evidence and when it's appropriate. So then something to think about as well is the prosecutor's reputation and the judge's reputation. And maybe what I mean more by this is more of kind of their trial record per se, especially with the judges and with the prosecutors. Their trial reputation goes into how many trials they do, whether they're newer, older, younger attorneys. And something that I won't say here as far as the best way to play it, gauge it, and judge it, but there is strategy to this. There's also strategy to to even pre-trial understand certain prosecutors are much more flexible when it comes to plea agreements, and you can negotiate a lot better with them and get them to agree to something that maybe another attorney would not be able to get, or maybe something that another prosecutor would not be willing to provide. And that's something that's important because prosecutors hold a considerable amount of power when it comes to a criminal case and criminal negotiations. And if there's a case where you can get a better deal than probably anybody else, that might be something that you consider as taking a plea versus going to trial on that. On the other hand, there are things to consider, such as the amount of work. If you have a lazy prosecutor who doesn't go through and review your case as hard or as much as they should, that might be something where you end up going to trial on it because you say, well, shoot, I hope they didn't prepare for this. These are strategies that are very deep, nothing that you really truly want to maybe roll the dice on, but there are things to consider, factors, and of course your attorney will be advising you of all of this. And I should have mentioned it earlier, and something that I mentioned with all of my cases and make videos about this for each of my clients is the decision whether to take a plea agreement or whether to go to trial is always your decision as the client, as the defendant. You have the 100% say. Us as defense attorneys, as my law firm, I'm here to educate you and advocate for you. Educate you about what's happening, educate you about maybe the best way to go about your case, educate you about whether you should or shouldn't take a plea deal, educate you about whether you should or shouldn't go to trial. Of course, you make that decision, and it doesn't always happen early on. Sometimes it happens later on in the case. But either way, the entire time, your attorney advocates for you. Whether you go and you say, look, I want a plea deal, then we're going to advocate as hard as we can to get you the best plea deal possible. And if at the end of the day, the best plea deal isn't what you want, then you go to trial. And then we advocate for you again in front of a jury to the judge and make sure that you get the best trial result possible. Something to think about is the judge as well. Is our experience, we encounter many judges, but we frequently see more than others. And when it happens to get a plea deal, and say there's an open range, so say the judge has discretion in your sentence under the plea, then we want to make sure that we have a good judge that's going to sentence you more favorably than maybe somebody else. That's an advanced move that I get into later as well, but it's something to be, very considerate about and to understand, especially if you would get into what's called settlement negotiations. We want to make sure you have a good judge with that. That way your sentencing becomes more favorable for you as well. One of the big things that I think everybody, focuses on more, and I didn't want it to be the first thing because I don't think it always should be the first thing, is the maximum sentence you're facing. It's one of, like I said, easily the biggest considerations that most people actually think about and worry about and focus on, and it really means that much. I mean, I'm not downplaying the seriousness of your maximum sentence, but there's a lot to it. And if you're not given the accurate information beforehand, in what's called a Donald advisement, or officially on the record it's a Donald advisement, or quite frankly you just get the right advice from your attorney that says you're facing this much time if you lose at trial, which is why maybe a plea deal is more in your favor. That's something that's very important. Arizona, Maricopa County here, we have very, very, very strict regulations as far as sentencing goes. We have minimums, we have maximums, we have presumptions, or the average sentence you should be sentenced to. And this is something that we don't like to say maybe politically here in Arizona, but we have mandatory minimums for different cases, for the level of certain cases. If you're a repeat offender, we don't have what's called a 3 strikes rule, but we have a category 3, and it's significantly worse than category 2 and category 1. And that's just the simple nature of what we live and work with here in Arizona. It's not anything that I agree that is fair. Defense attorneys did not make it. Most judges didn't make these laws. They came from the legislator. They came from our politicians, and it's something that hopefully changes and gets better. But there is a reality to many people's cases that the maximum sentence might truly outweigh any real thought of winning a trial. And I know that's hard to say. I know that's hard to stomach sometimes. even if there are really good cases, and the defense attorney says, look, you should try and really win this case. We really think you can win it. We think you can win it. We think you can win it. You've got to go to trial. At the end of the day, you're the one who makes that decision. And like I said before, we educate you about, your chances and the things that are going to likely happen at trial. And then we advocate for you the best we can, the best that anybody can. And at the end of the day, you're the one who has to live with the consequences of that. Of course, if the case is dismissed or if the jury comes back not guilty, then that is the best outcome you could possibly get. If it comes out unfavorable and you are found guilty and then you are facing some of these mandatory minimums, that's where the big consequences happen, and why you must be in communication with your attorney. That way you're not surprised the day of a plea agreement, negotiation, or at trial, what you're actually facing. And I've seen so many people who hire me after they hire other lawyers, or they've had public defenders where they got the wrong information, or simply no information is usually what happens. And they get to see what reality they're actually living in there. So it makes a big decision on whether you accept a plea agreement, which could be significantly less than the mandatory minimum, or you don't. So continuing on, and this is the last thing I kind of like to tell and to help people make a decision, because you're making that decision. I like to know as much as I can about you, but the truth of the matter is we work together for a short amount of time, typically less than a year, and there's only so much that I can learn about somebody. And so what I say is, you have to sometimes go with what your gut tells you. If you're going into this going, I've got to be innocent no matter what, and you go into this kind of with a blind eye, and you don't care about anything other than your innocence, and you might not, be in the best situation, the best mindset to make a decision of going to trial or taking a plea agreement. And hopefully you kind of go with what your gut feeling says at that point. If you have no other choice or ramification, if you can't hire a lawyer, and hopefully that's not ever the situation where you're making an ill-informed decision, but sometimes your gut decision will be the right one, the more accurate one. Of course, other things to consider that many people like to think is your age. I wrote in here your appetite for risk. This is more of your risk. Your risk versus reward. If there's a lot that you're risking that's on the line, whether that's your family, your education, your future, and you don't want to risk all that. A lot of people take that into consideration. Even if there's no punishment, but it's something that goes on your record, a lot of people, either put their pride beside themselves or in front of themselves and say, look, I'm going to do what's right. Or they're going to say, yes, I'm willing to, take a blow as long as this doesn't affect my family. Those are some of the things that are the reality that people face and understand and have to deal with. We think about some of the other things, of the physical, mental, and emotional ability to endure a trial that go into the decision of whether to take a plea agreement or whether to take a trial. What I really mean by that's what I say next is your prior experience with prison, and if any, your family situation. And really what I mean by that is what happens if you lose trial, if you end up having to go to prison, or even if you accept a plea agreement and you have to go to prison, where you are mentally with that, physically, emotionally. Like I said, it's not something you ever want to be surprised about. It's not something you want rushed. Even though our justice system sometimes can seem very rushed, especially if you can't make bond and get out to make this decision, you're going to probably make this decision a lot faster, and it might not be the most rational decision, which is where your attorney is supposed to come in and help you in a much more expedited manner. So continuing on, though, number 5 I have listed here is, do I really need a lawyer if I intend to plead guilty? Big question, get it all the time. I wish I didn't get it, because to me it's a no-brainer, but really, although you can plead guilty without an attorney, it is not advisable. Given all that is at stake, anyone that's charged with a crime should seek legal representation immediately before making any case-related decisions. I literally can't count how many times people have called me for my free consultation and said, hey Zach, I've got court next week. I've kind of got a plea from my public defender or no defender, and what do I do? And right then and there, I can tell them, look, you haven't been given any proper advice of what you're supposed to do. There's no way you can make a decision that is this lifelong and is never going to be able to really be undone. This is kind of the scenario, the situation I like to sometimes give is in baseball. There are 9 innings. Every inning you get to go out and reprove yourself and all that. Well, in trial, in court, there's no do-overs. There's no extra innings. There's no, second chances. It's not you had 3 attempts to hit a strike or a ball and a home run, a ground ball. Like, it's none of that. It's a one and done. You can't go back. You can't redo things other than very limited appeals. But when you make a decision, especially accepting a plea agreement, it's the end. It's something that goes, permanently, on your record, and these days it's permanently on the internet, and that's the biggest thing that you are going to be facing for the rest of your life. Is everyone who ever wants to look up something about you will very likely be able to find it on the internet, and that's why it's so important to minimize certain things in plea agreements and to get rid of as many things as possible. I've helped countless people in making a plea agreement decision where they didn't realize they were accepting a worse charge than they should be. They were accepting twice as many fines and fees than they should be, and that's just a big thing, and that it's so hard to help many people with. And when you're paying a couple $1,000s to hire a private lawyer, really what we're giving back most times in many cases where there are high fines and fees is we're saving you those thousands of dollars that you paid us. We're saving that from the exposure that you would have gotten with a worse plea deal, with a worse outcome in your case, whether that's less jail time, less fines and fees, less counseling classes, less repercussions that are long-term down the road with probation and other consequences. So a lot of benefits there that I just can't overstress. Number 6, though, what does guilty beyond a reasonable doubt mean? This is something we as attorneys get asked frequently, and I wish there wasn't such a vague answer. And I basically wrote out kind of the best quick answer I have here. Of course, there's more videos on all the different levels of what this means in a criminal and non-criminal setting. And so what I'll explain here is in our justice system, in the criminal justice system, a person is presumed innocent. That means until proven guilty. This means that if you're charged with a crime, you do not have to prove your innocence. Rather, the prosecution must prove every element of the charge against you beyond a reasonable doubt. This standard is not easily defined. I also want you to understand that this whole innocence word here is technically in here. You are innocent until proven guilty. And it brings me back to my point number 1 is I am innocent. Understand this is a different kind of level where there's different meanings with this that are actually given here. And like I explained, it's guilty or not guilty, even though there is a presumption of innocence. And this is a huge problem that comes to the jury when the jury has to hear this and decide it, and what us defense attorneys and prosecutors are allowed, what the judge allows us to tell the jury, because there's such a strong implication with the word innocence, and technically they don't have to find you innocent, they just need to find you not guilty, which is a lower standard, which means you just need to be proven beyond a reasonable doubt. And if they don't reach that reasonable doubt, they can't find you guilty. Very complex. It's not easily defined. Here's kind of the way it's easily broken down. Beyond a reasonable doubt means something less than beyond all doubt. Beyond all doubt is 100% impossible standard. What judges typically say at trial is there are very few things that we as human beings know in our life, in reality, with 100% certainty. There are very few things, and that's just the quite simple reality of us being human. There are very few things, if any, that we know with 100% certainty. So it would be an impossible standard to say, look, you must know, beyond all doubt that this person was guilty. And it's an impossible standard, so it won't be there. Now, the lower standard, lower than beyond a reasonable doubt, is something like, more likely than not. So this is the standard in civil cases. More likely than not is a lower standard than beyond a reasonable doubt. And then there's beyond all doubt, like I was mentioning. More likely than not, really just teeters over here on the seesaw and saying, oh, look, we leaned this way just a little more, whereas beyond a reasonable doubt has you all the way at the top versus, going 100% vertical. It's a different standard. Civil cases have a lower standard. Criminal cases have a higher standard, of course, because your life, liberty, and property is put at risk here. So practically speaking, beyond a reasonable doubt means that considering all the evidence, the jurors are steadfastly convinced that the charges are true and the defendant is guilty of the crime that is charged against them. What the steadfastly convinced, there's a newer word that's come out very recently saying that jurors must be firmly convinced. So firmly convinced that this person is guilty. I don't necessarily always agree with that language, but it is something that the judges have been allowing prosecutors to say because it came out in case law. It's not like they just made it up one day. But firmly convinced maybe gets us a closer definition to what beyond a reasonable doubt means, which, like I've been explaining, is such a convoluted and complex definition, and there are many pros and cons benefits to that I get into in some of my other videos, so I won't continue to bore you on the theory or why that is or isn't appropriate. Continuing on with what some of the questions I get is, what is the jury's role in a criminal trial? Fairly simple one. Arizona has very different standards, though. Many people always think, well, look, I want my 12-person jury. It's not true. It's not what you're going to get here unless you're facing certain crimes with certain punishments. Will you actually get 12? You're going to get less than that. Jurors in a criminal trial are not obligated to piece evidence together until they arrive to the truth. This is the common misconception that we like to lead and believe that, look, the jury is going to find evidence piece number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and look, that all adds up to your entire case. They found the truth. They're not really there to do that. I know it's hard to believe. I know it's hard to see. Just as this, brief mention of it. Of course, I go into it deeper in other videos. But it's not their job to solve the case. Rather, it's the juror's job to determine whether the government, with the prosecuting attorney, has met its burden of proving guilt beyond a reasonable doubt. I know this is a hard thing to kind of wrap your mind around without going deeper into examples and showing what this truly really means, which is why I recommend watching more of my videos. But the jury's role here is very limited. They don't need to know everything. They don't get to know everything. They don't solve the problems. They don't solve the crime, the murder, the stabbing, the assault, whatever it is. They don't solve it. They basically just get a look at the facts of the case as presented to them by the prosecutor. The defense, the defendant, we get to present evidence that maybe rebuts that or presents a different theory. And the jury at the end of the day gets to determine the facts of the case and whether something actually happened and whether they're firmly convinced that this person is guilty, guilty beyond a reasonable doubt. Finally, the last thing I have listed here is, the best advice for somebody facing criminal charges. Number one, it's so easy, it's so repetitive. I'm sure you've heard it a million times before. Is be quiet. Don't talk to the police. As number one. But I get a little deeper into this. As the most common mistake made by criminal defense, by yourself, someone you love, is talking about your case. I know this sounds counterintuitive. I know it's so hard to resist this, but the key to avoiding this mistake is simple. It's easier said than done. Don't discuss your case with anyone other than your criminal defense lawyer. Someone like myself, someone where everything you tell me is confidential, which means it's kept secret, which means I can't go out and tell anybody. I can't use it against you. I can't betray you. I can't do anything that's against your best interest. And the more you talk about your case, social media is a big thing these days. The more you put out, that basically becomes a risk. You need to remain silent. You need to exercise that right. Advise your loved ones, your family, your friends, coworkers, to do that as well, especially if they were involved in any way in the case. They need to know that they have rights, and they need to call me and speak with me, and I can advise them of their rights, that they don't need to go talking to police, prosecutors, adding more evidence to your case, just like you don't add more evidence to your case. There are legal things that can happen if they are forced to testify under subpoena, so on and so forth. And one of the biggest things is always just when you come into contact with police and you're doing something wrong, it's never a good idea, or any idea ever, to admit that you were doing something wrong. It works against you every single day of the week, and many people think that if I'm truthful to the police, they'll go easy on me, this will be easier, and they'll just let me go. And the reality of it is completely opposite. It's false, and you're going to get in trouble for it. So ultimately, those are some of the main 8 things that I think I get asked probably most frequently. Of course, there are many other things that I get asked on a day-to-day basis that are also very important, that I'll more than happily go through. If for whatever reason there's more that you really want me to go into, please let me know, contact me. And obviously, if you or a loved one is experiencing anything like this, you have any questions about anything that's happening here, you want to hire a firm that is going to put your mind at ease and help represent you through your entire case with a good confidence that everything is going to be done the right way. Please give me a call. Please let me know that you want a free consultation, that it's going to be 100% private, and I'll be more than happy to make it happen. And of course, don't feel that shame or guilt that what you've done is wrong and there's no way to make anything right at this point, because there is.